The broadcast is now starting. All attendees are in listen-only mode.
Welcome to the webinar. My name is Marty Schenkman, and I'm joined by Jonathan Blotmacher. And we're going to talk to you today about guiding clients to use the current high temporary exemptions. We have first a word from the host and sponsor, Peak Trust, but I don't think it's Brandon. Somebody from Peak was going to.
Good afternoon, depending on where you're at. This is Matt Blotmacher with Peak Trust Company. Joining us today, we have two fantastic presenters for today's topic. And as always, Peak Trust Company is honored to be able to support them. And for those of you that don't know, Peak Trust Company, formerly Alaska Trust Company, as a full service provider of fiduciary services, focusing on, of course, trusteeship. We have offices in Alaska and Nevada. The name change happened in 2016 when we opened the office in Nevada. And our mission is to facilitate, protect, and preserve our clients' wealth, vision, and legacy. We work with trusts, IRAs, donor-advised funds, and other accounts of all kinds, shapes, and sizes, including the difficult ones. While we're a full-service provider, our services are unbundled, and our core business is really working with advisors to help them achieve their clients' goals. If you ever have questions, please don't hesitate to contact Brandon Centula, myself, or any other member of the Peak Trust Company team. Our contact information is on the materials here today and can also be found on our website, www.peaktrust.com. And I'll keep it short and sweet. Thank you again for joining us today. We're pleased to sponsor this presentation, and I'll turn it over to Marty.
Thank you.
Marty, this is Jonathan. Why don't you first tell them about the article that you and Joy Matak and Bob Keebler and I did that was just published in Steve Leinberg's Lisi publication, and how they can get a copy of that.
So one of the hot topics for all of us right now is rethinking what to do with retirement plan benefits in light of the Secure Act, which made radical change to the stretch IRA that had sort of been the magic elixir of much of the planning we did for retirement assets for a very long time. Jonathan, Joy, Bob and I wrote an article that was just published in Leinberg. We've posted a PDF of the article on Schenkman Law, my firm website, SHENKMANLAW. In the blog post, you'll see a link to it. If you're subscribers to Lisi, you can get it from Leinberg's website. If you're not, you should be, because it's really a tremendous resource for everybody in the estate planning community. We're not going to talk about the Secure Act today. We're going to talk about using the exemption. And I just want to explain the slide. I don't mean to be political, and any comments we make are not political. We're just really trying to guide you to the ways you can guide your clients. We all know for certain that in 2026, under current law, the exemption will drop from 10 million inflation adjusted back to 5 million inflation adjusted, which is a significant change. We also all know that, and I may be wrong, but I believe every Democratic candidate has proposed significant hardening and restrictiveness of the estate tax. Bernie Sanders has a proposal. Gomez proposed an almost identical, or maybe identical, in the House to what senators proposed in the Senate. And these will dramatically reduce, potentially well before 2026, the exemption. So it seems to me, and I think I'm speaking for Jonathan as well, that one of the key things we all need to talk to our clients now about is how and why they should use the exemption before it goes down. And on the slide, we know it goes down, as I said, in 2026, but it could go down after this election. If this election stays Republican, it may go down after 2024. Clients need to plan to use that exemption, because if there's a shift in Washington, as indicated on slide 6, this will be something that's very significant. And we're going to talk about a lot of different planning ideas that can be used for you to guide clients to use exemption. And we're going to talk about some of the developments in this area that I think are really critically important in ways you can infuse flexibility into the planning. Jonathan, what I'd like to do before we jump in is just point out to those listening, this is not only for your clients, this should be for everyone on this call as well. There have been a spate of disturbing malpractice cases against estate planners. There was one in California, the name escapes me, it recently survived summary judgment, where the claim was that the trust set up in 2012, and you all know how crazy things were in 2012. The settlor, the income tax burden was too great, and she sued the attorney on the basis that the attorney should have done financial modeling or forecast to show what the cash flow would have been to her with the tax cost of creating this grant or trust. I mean, again, I don't have all the details of the case because we're not involved in it. We only have what we could read in the public records, but it sounds like the plan was successful. I don't know any attorneys that actually do financial modeling, and while a tax reimbursement clause could have been put in, maybe possible that the Canton add one, it just seems disturbing that a colleague of ours is being pulled through a lawsuit for doing the kind of planning we all do. And there's a number of other very major cases like that that are equally worrisome. So please think of this planning that we're going to talk about, not just for clients that may be trying to reduce an estate tax, but for yourselves, also for estate tax purposes, but especially for yourselves for asset protection purposes. And that I think can make this, bring this home. Jonathan, one of the things that we've talked about as to why it's prudent perhaps to use the exemption is the anti-clawback provisions in the regulations, that they're not going to have clawback. Do you want to comment on that on slide 9?
Yeah, people have been concerned that if they use their exemption today, let's say, today it's about 11.5 million. I make a gift of 11.5 million. It's protected from gift tax. But when I die, the exemption, let's say, has gone down to 3.5 million because the Democrats have taken control. And are they going to claw back the entire 11 million into my estate so that I only can protect 3.5 million? Well, the IRS in its regulation says will not do that. If you use, even if it drops in the future, of course, Congress could change that by future legislation, but the IRS says we will not claw any part of that gift back. However, there's an important thing to realize. You might say, well, look, I've got an $11.5 million exemption back to, basically 5.75 million by 2026. So I'm going to make a gift of half of the 11.5 million today. And I will have used it. So by the time we get to 2026 and I make a gift thereafter, I die thereafter, I will have gotten the benefit of using the extra exemption that now exists in the law that's going to go away by 2026 unless there's an additional legislative change. You can't do that. If you want to use any part of the enhanced exemption on a permanent basis, you've got to give it all away. You can't give away 5 million or give away 3 million or give away 8 million. If you want to use the enhanced exemption, that extra amount, you're going to have to give it all away. You're going to have to make a gift of $11.5 million. Now, there are a few of you on the phone, probably other than Marty, who can easily give away $11.5 million and say, I don't care, I got so much money, I'm never going to want it back. My experience is that people are selfish. I'm sure all of you who have clients who say, can I give more to my kids? I want to give more to my grandkids? Most of the people I represented, regardless of how wealthy they were, it's always, what about me? What if I need that money back? And now if you want people to use the exemption, either to get money to their kids now without paying tax, and if they don't get effective use of it later, that's okay, because they could get money to their kids. They want to get 2 or 3 million to their kids today, or they want to get 5 million to the kids, or they want to get all 11 million to the kids. But you're going to have the pushback about, what about me? What if I need that back? And we're going to focus very much on that. So Marty, let's go to the next slide.
Well, I want to tell everybody why I have so much wealth. It's because I have a collection of autographed photographs of Jonathan Blotmacher fly fishing in Alaska that I sell online. Let's go to the next slide. So we've talked about clawback, and I think the bottom line is you want to act, and your client should want to act before something changes. Let's change gears and talk a little about the tax proposals that have been made. Now, I know that these aren't being enacted now, but if there is a change with the Democrats in 2020's election, these well could be enacted. And these are not just proposals that the candidates are talking about. Senator Sanders had proposed the tax bill for the 99.8% Act in the Senate, and Congressman Gomez has proposed a comparable bill in the House. So the pieces of proposed legislation. And they're not far-fetched or unique because these are all based to a great degree on many of the same proposals that President Obama had in his Green Book many years in a row. So there's certainly legs to this, and the growing deficits could certainly be an issue. But let's take a look at what some of this does, because this, I think, will not only help you guide your clients to do planning before, because we don't know, as Jonathan pointed out, the effective date of this legislation, but I think it also is critical for us as practitioners to see why we may want to do the planning. And on the top of slide 14, it's critical to see that one of the changes that's been included in a lot of the Democratic proposals is not just the $3.5 million estate tax and GST exemption that Jonathan mentioned, but a mere $1 million gift exemption. So for you as practitioners, for physician clients who are uniformly always concerned about asset protection, a $1 million gift exemption will make it incredibly difficult to transfer assets into protective structures for asset protection planning purposes, unless you use incomplete gift trusts. So right now, if you have a client with a physician with $5 million of non-retirement assets that he or she wants to protect, you can set up a trust, and we're going to talk about the structures in a few minutes, and just make a gift. What happens when that exemption is reduced to $1 million? Well, in the old days, when we had a $1 million exemption in physician clients, we would do things like grats, family partnerships with discounts, but as you're going to see real quick, those things are all in the chopping block too. So this would radically transform planning. In my view, and I believe Jonathan's as well, is if a client can get planning in place now, why not do it? We don't know the effective date of the legislation. And as we're going to explain, as many of you already know, planning is done appropriately, and we'll define some of that, but creatively, flexibly, with access, which we're going to talk about. There's really no harm in the client doing the planning out. If the exemption in the law doesn't change, they've just gotten themselves good asset protection planning, and they may even enhance their state income tax planning if the trust is a non-grantor trust or gets converted to a non-grantor trust. So it is really the only downside, honestly, to the planning is the cost and time for the client planning process. Let's
keep in mind that the Supreme Court has said that the Congress can make changes to the tax laws retroactively, not because of a mistake, but just because it wants more revenue. So it's possible that a bill could pass in 2021 to the beginning of that year, or possibly even into this year. Now, I wouldn't stop planning because of that theoretical possibility. I think politically they will only make it begin in 2021. Maybe they'll make it 2022. But remember, when Donald Trump was elected, the bill got passed in 2017. When he took office and the new Congress they had that all done before the end of 2017, with many of the changes retroactive to the beginning of that year. Many, of course, more were held off to 2018, but there were some that went back to 2017. That's a fairly common thing to happen. So Marty and I believe get your clients to act as quickly as they possibly can.
You know, the Secure Act that we mentioned very briefly in the beginning, look what the Secure Act did. We've all had clients that had very large IRAs, converted them to Roth, and we're going to bequeath them to grandchildren to get that incredible stretch. The game's over, and they incurred an income tax to do it. It's in effect a retroactive change, so no one should be surprised by this. A couple of points from a practice standpoint. we have footers on the bottom of all the bills that go out to clients. And in those footers, we've indicated the importance of planning before the laws may change. And I've also briefly indicated that there's no assurance of future legislation. And that way we're putting everyone that we do work for on notice that, one, you should be planning because the game rules may change. And two, we can't give you any assurance about what the effective date is. That way, if we don't say it to a client, we certainly try to, if we don't put in a memo that's going to a client, it's in the bond bill a caution that we can't control the effective dates and it may impact what they're doing. We also have something like that in the engagement letter, the retainer agreement for each client. Something else that I added just recently to our engagement letter, our retainer agreement, we all remember the tidal wave of work at the end of 2012. And near the end of 2012, it became very difficult to get work done in time. And you couldn't find an appraiser. If you did find an appraiser, they'd give you a number but not a report until later in 2013. In anticipation of that possibly happening, and I'm not saying we know it will, but if we get closer to the election and it appears that a Democrat may win, we may have the same kind of tidal wave at the end of this year that we did in 2012. So I've put a caveat in our engagement letter that, you know, we can't assure that all planning will be completed by the end of this year. I don't want that if somebody shows up closer to the year end and we physically can't get the work done, that it's a problem. Obviously, we're going to do what you would all do and try to not accept work if we can't do it. But I want to put clients on notice that if this develops into a 2012, we all of us, we're going to have a very difficult time getting work done. Let's go back to slide 17. Some of the other changes proposed are valuation rules. So just bottom line on slide 17, most discounts may be eliminated if this kind of legislation goes through. So think back to my comment earlier that if we have $1 million gift exemption, in the old days we could use grats, and we're going to tell you what's going to happen to those. But we used to always, we would commonly set up, for example, an entity like a family limited partnership and take discounts to leverage more assets using the $1 million exemption. So that may be gone. So it's not just the reduction in the exemption, but it's all these other potential changes too. On slide 18, the proposals made for grats basically eliminate grats. If you have to have a gift equal to 25% of the value going in, no one's going to do a grat or a minimum of $500,000. If the minimum term for a grat is 10 years, a lot of our older clients, it won't be practical to do. So just a couple of thoughts that we may come to later. There may be different applications as we get closer to year end, and we'll talk about it, but grats could be over. You need to rethink use of grats too, because if you cannot roll grats, if cascading grats don't work because next year or the year after when a 2-year grat rolls through, or 1 year from now if an annuity payment comes in, you can't regrat it if the law changes. So we really have to rethink that. Grantor trusts on slide 19, very harsh rule. They are talking about having all the assets in a grantor trust included in the estate of the grantor. That would effectively eliminate the use of grantor trusts. So, that to me is a suggestion that if a client wants to do grantor trust planning, the sooner they do it, the better. Maybe it'll be grandfathered. Like Jonathan said, we don't know. It could be retroactive. But again, I think the earlier they do it, the more likely it is to be grandfathered. And by the way, that's something else to think about with clients evaluating using grantor versus non-grantor trust. We all have situations, a client selling a business where a non-grantor trust, an ing of some form, or a salty slat of some form will make sense. But if we're going to do a non-grantor trust, it may also be prudent to create a grantor trust for a client, so at least they have a vehicle that may be grandfathered if there's future legislation. Jonathan, any comments on that?
Yeah, I would make sure if you're doing a grantor trust that you expressly provide that the trustee or someone else can take action to turn grantor trust status off. Because it may be that they're going to say all grantor trusts, regardless of when created, will be includable in the estate of the grantor upon her death, or if grantor trust status is turned off during lifetime, everything in the trust will be deemed to be a gift that the grantor has made taxable gifts to the trust already. So that's critical to think about. How am I going to allow grantor trust? And you need to expressly provide that the people who are involved can do it without any liability for doing that. I mean, this change on grantor trust is the biggest potential change there, in my judgment, because it means you can't do a GRAT, because if all GRATs are going to be grantor trusts, and now even if you have a successful GRAT because you had great appreciation in the assets contributed to the trust, and there's a lot left or will be a lot left after it's received the annuity payments back, you're still going to have estate tax inclusion potentially. So you've got to be sure that you can turn grantor trust status off. By the way, this is not a new proposal coming out of Bernie Sanders. This is one that the Treasury started making almost 10 years ago. The reason they say it's fair to pull that back in is because the grantor has been able to pay the income taxes on the trust income, which is like making an additional gift to the trust. The IRS finally conceded in Revenue Ruling 2004-64 that the grantor paying the income tax on income attributed to the grantor under the grantor trust rules was not a gift to the trust. Originally in 1999, they'd come out with a private letter ruling saying it was a gift. I wrote a letter to the head guy at the IRS and said, your position is so ridiculous that you make a gift by paying the taxes that is attributed to you under the grantor trust rules, that if a taxpayer did that, you'd have her put in jail or put in an insane asylum. They quickly withdrew the private letter ruling, and it was 5 years later, 2004-64, that they said, okay, we agree that since Congress says this income is yours for income tax purposes, your payment of the income tax is not a gift to the trust. So that's the key. They're saying it's only fair. You've been able to make these tax-free contributions to the trust by using grantor trust status. We're going to pull it all back into the estate, except for dollar the amount of gifts that you've made to that trust.
What about just giving a broad power to a trust protector, Jonathan, in case the provisions that create grantor trust status themselves don't provide a mechanism to turn off? So, for example, if there's a power for someone to loan without adequate security, that creates grantor trust status. Maybe that can be relinquished. A swap power may be relinquished. But what about just creating a general provision giving a trust protector the authority to take any action necessary to turn off grantor trust status?
Well, I think that's a better idea than having the trustee do it, because if the trustee turns off grantor trust status, the trust is going to have to pay income tax on its income, and some beneficiary might say, well, that's violating your fiduciary duty. You have it expressly in the trust. The grantor says, you know, the trustee can take these actions. Maybe the trustee is protected. But as Marty is suggesting, having someone else have the power to take it away may be the best way to go. If you're going to do it through a decanting, because you have a provision in there and basically you can't take it away, you might say, well, what I'll do is I'll decant and pay it over to a new trust, which will turn grantor trust status off. Then the trustee, you know, is not going to be sued if it's really expressed. But I think the best thing is to have some outside person have the ability to do that.
Would you want that person in a non-fiduciary capacity?
Absolutely, because if they're a fiduciary, the beneficiaries may sue. There's a lawsuit going on down south where the grantor was very unhappy that he was paying all the taxes, and he has sued the law firm, he has sued the trust, because he said, I really didn't understand how much this was going to cost me because it was grantor trust status. And I doubt that many people expressly say to their client, you realize you're going to pay all the income tax, and it could substantially reduce the amount of wealth you have over time. This is a case where there was a big gain that was taken in the trust, huge amount of capital gains tax due, even though the guy lived in a non-income tax state, and he has now turned around and sued everybody, including the law firm. So again, you can't cover everything with your clients, but you really need to think about this, especially in light of these proposals.
Annual gift exclusions reduced to $10,000 per donee, $20,000 cap donor. We've never had a cap per donor. Think what that does to even your typical insurance trust. So again, significant changes. Let's skip through some of the rest of this and start to focus on some of the planning and steps that you may want to take. Just a quick thought on downstream planning. Everybody, slide 24, everybody talks about upstream planning. I don't think you're allowed to go to a conference where somebody doesn't talk about upstream planning. So you create a spousal lifetime access trust for the client's spouse, and you give the elderly mother-in-law or father-in-law a general power of appointment or some variation thereof so that it's included in their estate. Upstream planning. What about downstream planning? Many of us have wealthy clients. An untapped resource is potentially the huge exemptions of their children. So when you have families with a substantial wealth, is there a way to safeguard or use the exemptions of the children, the next generation? Jonathan, you want to comment on that?
Yeah, one way, obviously, the senior generation could make gifts, but they'll soon run out of their enhanced exemptions and wind up paying gift tax, which is an anathema to them. That's not what they want. But they could loan money to their kids, and the kids could go ahead and make gifts. In fact, they could do their own incomplete gift trust, so they could remain indirectly a beneficiary. But it's talk more about that. But remember, if you have 3 children, they have, in round numbers, 35 million in exemption. And that's going to be cut in half in 2026, if not before. In addition, you could get both of that out of the estate as well. So it makes a lot of sense to consider ways of getting property over to children. Again, you can do it through a general power of appointment. By the way, a general power is a general power, even if you can only exercise it with the consent of some non-adverse party. So, for example, Marty's clients come in, we've got 3 kids, we want to be able to have them use the exemption. Marty says, fine, we're going to loan money to the trust, and the kids are going to renounce their general power, and they say, well, what if they exercise it? And Marty says, they're going to have my permission to do that. Even though they have to get someone else's permission, as long as that person whose permission needs to be obtained is not an adverse party, like a beneficiary of the trust who would lose status as the beneficiary or a remainder beneficiary, that will put it in the estate and gift tax arena of the child. And that means that you'll be able to use the children's exemptions, which can save a tremendous amount of money for the family.
If you use a loan approach, be mindful that the child that is getting the loan, the borrower, does not have adequate resources. The IRS would recharacterize or could recharacterize that purport. But the family is wealthy enough to do this planning, probably have several existing dynastic type trusts already out there, of which those heirs are beneficiaries. And you may have the trust guarantee the loan so that it would have economic substance and perhaps be respected. On slide 25, let's change gears for a second. And I think this is very important for a lot of the, let's call them moderate wealth, and the term moderate's in quotes because it's relative to the very, very high exemptions. For many of our clients, it may make more sense for one spouse, not both, to make an exemption. And I think Jonathan talked about this earlier in the context of the anti-clawback regs. If we have a couple that is going to give $8 million of gifts, common planning in 2012 is for each spouse to set up a non-reciprocal spousal lifetime access trust, put $4 million in each, and that way each spouse was a beneficiary of the other trust and they had access to the money. But now if we were strategy to use an $8 million gift, if each spouse makes a $4 million gift to a spousal lifetime access trust, for example, exemption drops from 10 million to 5 million inflation adjusted, each spouse will have very little exemption left. But if instead just one spouse, the husband on the bottom of 25 in the example, gave his $8 million exemption to a spousal lifetime access trust for wife and descendants, and the exemption drops to 5, the husband will not have any exemption, but the wife will have retained her entire $5 million exemption. So they may actually be better off in this sort of mid-tier wealth range doing this. And where I've also seen this kind of planning work very well, and I just thought of explaining it in a different context, we're going to talk about a lot of ways to get access or preserve access to money for clients making these gifts, because that's critical to clients using these large exemptions. One of the ways that this example has played out very, dovetailed very well with the client planning, if let's say in the example on slide 25, the husband had a very large retirement account or pension plan that could not be transferred. If the husband has that large retirement account and sets up the slat with non-retirement assets for the wife, in that instance, if there's a premature death, the husband still has significant assets in his own name to benefit from, and that may alone be sufficient to solve the access issue in the event of premature death. So again, not all clients should set up both trusts. Here's a practical drafting thought that I've done with a number of clients, and I'll explain what I'm doing and why. When we have a situation where, let's say, one spouse, the husband, to continue the example, is going to create a slat for the wife, I suggest to the clients it may make sense for us to draft both spousal lifetime access trusts now, even though the intent is only to use one. And the reason that some clients have gone for that, a lot easier for us as practitioners, as draftspeople, to create a spousal lifetime access trust for both spouses at the same time, because while you're drafting one spouse's trust, you're very conscious of what you're doing to differentiate that trust from the other spouse's trust in order to deflect a reciprocal trust challenge. So it may be easier for us to do them both at one time. I also think there's significant economies of scale. It's a lot easier to draft both spouses' trusts in terms of cost at one time. But the real point for many clients is a lot of clients that are opting to do one trust now, if they see the political climate solidify in their mind of shifting to, let's say, Bernie Sanders being the next president, they very well may want to have the other spouse create a slat before the election as well. And, you know, again, think of what happened in 2012. So by getting the second slat drafted, maybe leaving it in rough form and not proofreading it or modifying it, but just having it there as a rough draft, can expedite the planning before year end if that comes up. Jonathan, why should people think about some type of, whether it's a self-settled trust or any of the variations like SPATs we're going to talk about, but maybe you can just comment why this is so important to consider in the type of planning we're doing.
Experience, clients are very hesitant to give away a tremendous amount of their property and not have access to it. I can tell you a lot of stories about with enormous wealth who really didn't want to give anything away. And in fact, as many of you know, I developed the Domestic Asset Protection Trust legislation. I tried to get it through New York, but I was beaten back by my colleagues who likened it to a law that would allow wife beating again. But the brighter people in the state of Alaska said, do it here. So Alaska was the first state to do Domestic Asset Protection Trust legislation. And I didn't do it in order to help people bilk their creditors. I did it so clients could get back at the assets if they ever needed them. And it's been very successful. There are now 19 states in the United States. The latest two are Indiana and Connecticut, which allow people to create self-settled trusts for themselves. And as long as you haven't made basically a fraudulent transfer or trying to bilk a creditor when you create it, you can create one. And at least under the laws of those states, you're able to get something back in the discretion of the trustee. And again, I did that to try to get my clients to do more meaningful estate planning. It's also very good, obviously, for asset protection planning. So if the client knows that she can get the assets back if she needs them, and perhaps you're going to even give her or a friend of hers the power to remove and replace the trustee, and the fact that the exemptions are going to disappear at least in half by 2026, unless there's a law change which extends it for a longer period of time, you may be able to get your clients to act more promptly in that. In fact, it's something that perhaps you want to consider for yourselves, because if you can get it back and you can avoid claims of creditors, I think it's very good. And one thing I want to point out, right after the Alaska Trust Act passed, I was invited to the annual meeting of the bankruptcy judges in the United States. The Bankruptcy Code is a federal law. The judges are all federal judges. They're very, very powerful. And they invited me to talk to them about this new Alaska legislation. And I told them the reason I did it. I said I wanted to do more effective estate planning. And every judge who was at that program, there were about 30 who met with me, said that if they knew you had done this in order to do more effective estate planning, they would not pull it back into the bankrupt estate. Now, the law that was passed later, 548E of the Bankruptcy Code, which says if you go bankrupt within 10 years of creating a self-settled trust or similar device, it goes back into the bankrupt estate, but only if the debtors can prove that you are trying to hinder, delay, or defraud a creditor. Well, if you come in and show that I didn't do this to hinder, delay, or defraud a creditor. I did it because the exemptions were going away. I think you've made it virtually foolproof. So that's something else to consider for yourselves and for your clients.
Couple of comments. One, and I'm assuming you all know this, so I'll just say very quickly, but in order to backstop the transfer to any of these trusts that we're talking about, DAPs or otherwise, you should have a balance sheet that the client signs so that it shows that they have a positive net worth of significance even after the transfers. We have a forensic accounting firm do an analysis of like due diligence on every client that's doing these large transfers, even for other trusts, just not self-settled trust, because I think that can help deflect a fraudulent conveyance claim if we, in good faith, had an independent firm corroborate that there were no claims or issues that could be identified, and we have the client sign a solvency affidavit regardless of whether or not state law requires it. So getting those steps done can help backstop all of this. And just to, from a confessional standpoint, I created a self-settled DAP for myself in 1998. Jonathan, wasn't it 97 when the statute was first passed in Alaska?
April 1, 1997.
So
effective as of that day.
Yeah, within a year of that passage, I created a DAP because I just thought it made a world of sense, and why not have it? And Peak Trust, who is our sponsor, is and remains my trustee. So I think that's something that I suggest that many of you give thought to. It's a perfect time to do it. As Jonathan said, so this is not something that there's only one state as in 1997, but we've now grown to 19 states, and likely we'll have more join that list. Jonathan, what about some of the concerns or issues? You mentioned the Bankruptcy Protection Act. Do you want to comment on slide 28 and 29 about some of the other concerns with self-settled trust? Because even though the concept makes sense, and I don't believe we have case law that says they don't work, we have some very bad fact cases, but what are some of the concerns that practitioners need to consider if they pursue this with clients?
Well, all states, either by common law or by statute, which haven't adopted DAP legislation, basically say that a self-settled trust is void with respect to the grantor. And a self-settled trust, as indicated at the top, is one from which the trustee may make distributions to the settlor. Obviously, if you've retained the right to the assets, you're not going to get protection really anywhere. But if you make it a discretionary trust, but the trustee can give it to you in all but these 19 states, the creditors of the grantor can get those assets. I mean, this is a quote from the Restatement of Trusts second. It's also in the Restatement of Trust third. Some states like New York I've got here, a disposition in trust for the use of the creator is void as against existing or subsequent creditors of the creator. Again, if you have a self-settled trust, it is permanently subjected to the claims of your creditors. It doesn't matter that you were just trying to use your exemption, you didn't need it, you weren't trying to bilk anybody. It's just a rule, and the rule says that if you create a self-settled trust, you don't have to show bad faith or anything. It's going to be void with respect to creditors if it is self-settled. And here it is again, Restatement third, as I said, has it. The Bankruptcy Code 548E has it. Basically, the bankrupt estate includes any self-settled trust or similar device that was transferred by the debtor, and he or she goes into bankruptcy within 10 years of that transfer to the trust. But it has to be made with an actual intent to hinder, delay, or defraud any entity. And again, if you can prove you weren't trying to bilk anybody, and as Marty said, you may want to make sure you can show that you've got enough assets to pay your debts. In fact, in Alaska and some other states require that the grantor file basically a statement of solvency at the time that it's done. You also can say, if you have a creditor right then and there, but you want to protect yourself from others, you say, this is supposed to be protection from all my creditors except Company Z, which is currently suing me. So that's another way to go. But again, and even if your state, you now go to Connecticut, you go to Alaska, you go to South Dakota, you go to Wyoming, you go to create a self-settled trust, and you say, I'm golden. if a court gets jurisdiction over you in a state where they really are hard on debtors like California, New York, even Florida, you're going to have a very, very rough time, because the creditors are going to beg the judge to apply that state's law, the forum's law. And if you have everything in one state, like everything is in Alaska, the trustees, the assets, and everything else, I think there's a good chance that a court in another state would decline taking jurisdiction over it, even if the suit is filed against there earlier. But please do not have a local trustee. Make sure that all the trustees are from self-settled trust jurisdictions, domestic asset protection trust jurisdictions. Even your trust protector should be in one of those. In fact, you're better off if you can make the beneficiaries there. So, for example, you create a self-settled trust, let's say in Connecticut, and you've got kids who live in Florida. Well, maybe what is done is that you create trusts in Connecticut for your Florida kids, and the trustee of the DAPT you created can make distributions to you or to these other Connecticut trusts. So at least you have an argument that it's all 100% in Connecticut.
I don't think many of the trusts go that far, but those are, thoughts of how far you can go. But we're going to offer some other options that are worth considering. So one of the things that's been talked about a lot, and some have called it a hybrid DAPT, what it is a trust that is a typical, let's say, for example, spousal lifetime access trust. I create a trust for my wife and all descendants, but I give Jonathan, as a colleague, in a non-fiduciary capacity to add back descendants of my grandparents. So it's a whole class of people that he may choose to add back as beneficiaries, and that would include me, because I'm a descendant of my grandparents. Now, that's been done and talked about a lot, and the concept is that this is not a self-settled trust unless and until Jonathan exercises the power to appoint me back, and until he does that, I'm not a beneficiary. It's not a self-settled trust. Jonathan, maybe you want to comment about this case that you brought to my attention, and I think it just raises a general concern about hybrid DAPTs.
Yeah, I mean, a hybrid DAPT is probably better and safer. In fact, some people say that the grantor can't be added in as a beneficiary for at least 10 years, hoping to avoid the 548E provision. But this case, in New York, said that where the trust protector had the power to amend the trust and make the grantor a beneficiary, that made the assets reachable by the health department in New York. Now, this was one of these trusts done to try to get people on government benefits, but the court ruled that the creditors could get it. Now, in this particular case, the trust protector, the person who had the power to basically add the grantor back in, was acting in a fiduciary capacity. Alexander Bove, who's a great lawyer in Boston and a real expert on trust protectors. In fact, he got his PhD from some institution in Europe by writing his thesis about trust protectors. Alexander says that all trust protectors are fiduciaries. Now, about a couple of years ago, Alexander and his lovely wife and my wife and I went to dinner, and he did concede to me, maybe he's changed his mind again, that if you are in a state like Alaska, which says no trust protector is a fiduciary at all, unless the instrument expressly says to the contrary. If you do your trust in Alaska and you expressly provide that the trust protector is not a fiduciary and owes no fiduciary duty to anybody, I don't think the trust protector has a fiduciary duty. And again, in this case, which is a pretty scary case, again, it's a lower court case in New York, from the New York Court of Appeals, the highest court, but it's kind of scary to think that if someone had the power to add the grantor back in, they're going to say it's a self-settled trust. And that's something you need to think about, and something to think about when you say, I'm going to have a trust protector or someone who can add the grantor back into the trust, and they'll think, you're trying to make sure it's not a self-settled trust.
Be also careful that if you give this kind of power to a trust protector, if that person is under state law or the instrument acting in a fiduciary capacity, you have a problem. So you do want at minimum somebody in a non-fiduciary capacity to act. Now, Jonathan, given the possible issues with a hybrid DAT, are there any other acronyms that you know that might be of interest on slide 31?
This is one that Mitchell Gans and Abby O'Connor from Anchorage, Alaska, and I came up with, and you can read all about this in the February 2019 issue of Estate Planning Magazine. What we decided is that we did never want a self-settled trust. And the way you ensure that never can have a self-settled trust, because remember, if the trust protector can add the grantor back in, maybe even in a non-fiduciary capacity, they might say, aha, this is a self-settled trust. And you're in California or New York or Florida or some state where they say creditors can get a self-settled trust. So what we said is, let's have a special power of appointment trust. Now, all of you on the line have drafted lots of trusts where you gave one or more beneficiaries a special power of appointment. Can't be exercised in their own favor or their estate, their creditors, the creditors of their estate, but it may be a narrow, only in favor of the descendants of the grantor, or very broad, anybody but myself, my estate, my creditor, the creditors of my estate. You can do that. But I've never had anybody say that just because you're a potential appointee under a special power of appointment that you are a beneficiary of the trust. Indeed, some states, Florida is one, which expressly states that a potential appointee is not a beneficiary of the trust no matter what. So what we said was, let's create a trust. Marty would create a trust for his wife and all his descendants. And then Marty would give someone in a non-fiduciary capacity who's also not a beneficiary. Maybe it's his best friend. It might be his 3 oldest cousins from time to time. But Marty arms these people with a special power of appointment, which can be exercised outright to descendants of his mother or grandmother, a class that includes Marty. And you can even say that these people who have the power can only do it with the consent of, say, Marty's lawyer, who's probably not going to agree to it if they are trying to harm Marty and going to exercise it in favor of one of his siblings, for example. Now, this, I think, really moves the ball tremendously, because you do not have a self-settled trust. There's no way the grantor can ever be added. In fact, your instrument will say you can't even, do a decanting to add him in, which happened in that Iannona case that we just looked at under the prior slide. So if you're going to convince a client or try to convince a client that you should use an exemption or any kind of thing where the client says, but what about me? How do I act? We're going a bunch of people who can exercise this special power of appointment to give you money. Now, again, it's only going to be exercised if there's a need. He knows he can always get it. It's kind of like it's in the trust for him. But because these people in non-fiduciary capacities and who are not beneficiaries can give it to him. So if Marty needs a new yacht, which he probably will within the next decade, and I got the special power of appointment, I can appoint the property to Marty so he can buy the boat. Or maybe I can convince the trustee to buy the boat, and then I'll appoint it from the trust over to Marty outright. This really, really is something powerful. It prevents it from being a self-settled trust. So even in a state like California or New York or Florida, you should be good to go. You don't have to worry about creditors coming in and getting it. Now, I would wear belt and suspenders. You can theoretically do this in any state, even a state like California, which doesn't have DAP legislation, because the grantor is not a beneficiary. And remember, merely being eligible to receive property pursuant to a power of appointment, I would wear belt and suspenders. If you're going to do a SPAT, I'd consider you go to Connecticut, you go to Ohio, you go to some state which has that has adopted DAP legislation. However, I urge you to not do it in a state with an income tax. As all of you know, there was a big case decided, the Kastner case by the Supreme Court back in June, where they wouldn't let North Carolina impose a tax on undistributed income of the trust merely because there was a discretionary North Carolina beneficiary. You don't want to go to a state which has an income tax, because the states are now going to expand how they impose the taxes. So you don't want to go to Ohio, even though it has good DAP legislation. You don't want to go to Connecticut, even though it has good DAP legislation. This is in my judgment, because it may be that you are caught there and they change it so that they can tax the income on a variety of different grounds, and there are at least 5 that they can use, and they can say, we can tax the undistributed income of this trust if any one of the following 5 things appears. And maybe some of those the Supreme Court will say is sufficient to cause this, to allow the state to impose an income tax on undistributed income. So go to a place like Nevada or Wyoming or Alaska or South Dakota. Delaware is okay as well, as long as you do not have a Delaware beneficiary. And I don't think Delaware is going to soon change that, because they've gotten so much trust business, in part because they don't impose any income tax on undistributed income of the trust unless it has a Delaware beneficiary.
So if there's an article Jonathan and I did on the Kastner case, I'll post it, but if you email me, my email's at the last slide, I'll be happy to send it to you. Another comment, Jonathan said that if you do a SPAT, do it in one of the jurisdictions, one of the 19 self-settled trust jurisdictions. I agree. It certainly makes sense to be safe. Another application of that concept, if you're going to create, which is a common planning tool for clients to get access to trust monies, if they're, to encourage them to make gifts and use their exemption, is a non-reciprocal spousal lifetime access trust for couples. I try to put as many, if not all, of the slats that I do in self-settled trust jurisdictions. My concern is illustrated by the following. If I have a slat to benefit my wife, Patty, and Patty has a slat to benefit me, if a distribution gets made to me out of Patty's slat, where do most clients deposit that? They'll put it in a joint checking account. And then if the other spouse, Patty in this example, writes a check out for the utilities and the gas and electric bill, she's just now used funds out of her own slat to pay for living expenses. And I see that as a possible issue. So if you structure your non-reciprocal slats in a DAP jurisdiction, if somebody wanted to challenge the validity or pierce the slat or say it's back in the estate, well, it's really just turned into a DAP, if you will, by that error, and doesn't necessarily fail. The other thing I like to do, we're on slide 32, to support the non-reciprocal nature of the slats. If I'm creating a slat for my wife, which I did in Alaska, if she creates one for me, I'm going to use a different trust company and put it in, let's say, Nevada, which she did, because now I have different trust companies, different state law. I think that's a great way to help reinforce the non-reciprocal nature of the two trusts. So non-reciprocal slats are another great tool that you can use. Now, there's lots of different variations. You can make one of these trusts a slat and put a SPAT provision in it. That's certainly not only a great way to differentiate the two trusts, but another way to give access. You could have a hybrid DAP and a SLAT, accepting or acknowledging some of the concerns and comments that we made. So the point is, you can use all the different variations of these different trusts that we've talked about in order to assure access so that clients are comfortable using exemption, provide an important measure of asset protection planning, and don't get hung up on the acronym, mix and match them so they work for the particular client. Now on slide 33, there's a number of things that can also be done to enhance some of these techniques. So one is, and I have this in my own DAP, is that I can't get any distributions for 10 years and a day after a gift has been made to the DAP to the Bankruptcy Protection Act 548E. So that's something that can be done. You just have to make sure the client has adequate resources. But 10-year fuse, because it certainly negates any argument that, you know, I didn't have adequate resources, and I think even to a degree that it was a fraudulent conveyance, because I can't get at it for a decade and a day. In some instances, practitioners will provide that the grantor can't be added back, or you may even add this into a SPAT, can't get a distribution, or the power can't be exercised unless there's a death or divorce. Why? Because if there's a non-reciprocal spousal lifetime access trust or just a slat for the donee spouse, so long as the donee spouse is alive and we're married, we can get access to that. Why take greater risk by adding me back? Reasonable compensation from entities. For many of our clients that have family businesses, real estate entities, can be owned, and they still may be entitled to fair compensation. But I encourage clients to have an independent, for example, appraiser or CPA firm confirm that they're taking reasonable comp, so it doesn't look like they've somehow retained an interest in that. There's other ways we can provide access to on slide 34. So the loan provision, where you can make a loan for at adequate interest, without adequate consideration, that provision we've used historically to backstop or belt and suspender grantor trust status. But there's another very valuable use of the loan provision. If I set up a spousal lifetime access trust for my wife, if I gave Jonathan in a non-fit capacity the power to loan to me without adequate security, I can get at the money in the trust if I ever need it by Jonathan making me a loan. So, and if I die owing my trust money, so what? It's just another great tool to access the funds in the trust. Another point on the bottom of 34, but you got to be careful as you're representing both spouses, is to use a floating spouse clause. Instead of naming my wife as a beneficiary of my trust, I say to whoever is my spouse at any point in time. Now, that's also valuable because if there's a premature death, which is one of the risks of a client accessing money in a slat that they create, if there's a floating spouse clause, should they remarry, they again have restored access indirectly through the new spouse to that trust. So really the key point here for these provisions, and this is the focus of what we wanted to cover in the webinar, is there's a myriad of different tools and techniques, trust techniques, DAPs, hybrid DAPs, loan provisions, floating spouse clauses, non-reciprocal slats that you can mix and match to come up with a mechanism, a plan that fits each particular client. And again, the goal is, in many cases, not all, you want to use this temporary exemption before it's dissipated. For many clients, including probably all of us on the phone, getting asset protection benefits is certainly a valuable benefit of doing the planning. And the key issue for many of our clients, and for probably all of us on the phone, is making sure we can access that money, because otherwise we're not going to make these transfers. And there's a host of different techniques that we've given you that can accomplish that. The rest of the slide deck goes through other planning that you may want to think about in light of the Democrat-type proposals and the reduction that's going to occur in all events, unless the law is changed, in 2026 of the exemption. Jonathan, do you want to cover anything else?
Marty, just let me go back and reiterate one thing. Almost certainly the trusts you create are going to be grantor trusts. But that means that you've got to have this mechanism to turn them off if they do pass legislation which says that grantor trusts, regardless of when they were created, come back into the estate. I'm hoping that they will grandparent all grantor trusts created before the effective date of at least the introduction to the legislation or the actual enactment of it. So that's one thing that you've got to watch. I also want to say something about one of the most effective things you can do for someone who lives in a state with an income tax, and create a so-called incomplete non-grantor trust, a so-called ING. If it's in Delaware, it's a DING. If it's in Nevada, it's a NING. If it's a KING. But you can avoid state income tax on non-compensation income by creating such an ING type trust. However, New York has now passed anti-ING legislation. So for those of you who represent New Yorkers or are in New York, you can't do an ING. However, and this is a great idea, I think. Let's say you have $500,000 a year of non-compensation income. You've been collecting assets, and you have income. You can do an ING trust for yourself or for a New Yorker as long as you make the gift complete. And here it's ideal. You've got this enormous exemption, which obviously very few of us on the phone can use. Why not create an ING trust for yourself, even if you're a New Yorker, and make it a completed gift? You'll use your exemption, discretionary trust, so it shouldn't come back in your estate. I would urge you to do it in a DAP jurisdiction, and it's not going to be a grantor trust. I mean, there are about 50 private letter rulings out there. Marty and Bill Lifkin and I wrote a two-part article in 2000, wasn't it 18, Marty, or was it 17?
Yes.
In Trust and Estate.
I think 18.
But go ahead and look at those, but think about it for yourself and think it for your clients. And even if they're in New York, what a deal. And by the way, even if they live in a state which allows ING trusts, they're going to be effective. Unlike in New York, you still make them completed gifts. Try to get it out of your estate, use the exemption, and also avoid income tax. I don't think life gets much better than that, does it, Marty?
Hey, I'd rather do that than go fishing, wouldn't you? Let me give you one practical comment in conclusion, and I know there's a lot more slides, but we covered the key topic that we wanted to cover, but there's a lot of other good information, especially for larger estates. But from a practical perspective, if you're sitting down with a couple and you want to do planning for them, and we've gone through perhaps 10 different variations, and there's obviously a whole slew of different variations on each of those, how do you practically draft this? The only practical answer, in my view, is to use document generation software. Because if you're sitting down trying to draft the myriad of different variations, tailor them for every different client that comes in, because each client's nuances are different, facts are different, desires are different, it almost becomes, I think, impractical, if not impossible. But with document generation software, you want to add a floating spouse clause, you click that provision. If you want to add a SPAT provision, you click that provision. If you want to create non-reciprocal spousal lifetime access trust as the building blocks of your plan before you may add on a SPAT or other provision, you can simply select those documents and move forward. So you really need the power of document generation software in order to make this a cost-effective, profitable for you, and practical step to do. And it makes it much less painful and I think much more rewarding as a practitioner. If you haven't taken that plunge, now's the time to do it. Any concluding comment, Jonathan, or I think we're good?
I think we're good. We're out of time, Marty, and we don't want to keep people beyond what we said we would keep them.
Thank you for joining us. Feel free to email Jonathan or I. Our emails are on the last page. And thank you to Peak again for sponsoring the program.